So Donald Trump's DC criminal conspiracy case is back in Judge Chutkan's court. Welcome to Law and Society. Please subscribe and let's talk about it. So on Friday, I believe the 2nd of August, Judge Chutkan received the case back from the circuit court, uh, giving Judge Chutkan the opportunity to have the evidentiary hearing to determine which of the acts that Donald Trump committed while he was committing acts alleged in the indictment were official versus private acts. So, right after getting the case, Judge Chutkan issued a status report date, which is going to be on the 9th of August, so in a couple of days, and then she's going to hold a hearing to schedule the evidentiary hearing. So the initial hearing to argue the status report and when the parties want uh, the evidentiary hearing to take place. So that is a week after. So this Friday will be the status report is going to be due, and on 16th of August is the hearing where Judge Chutkan has waived Donald Trump's appearance and will likely uh, determine a date for when the evidentiary hearing can begin. Now, I want to give a heads up, as I did when I read Hugo Lowell's article in the Guardian about the different ways in which Donald Trump's attorneys plan on derailing the evidentiary hearing. First is executive privilege. So the whole idea of you know Donald's former attorneys or employees asserting executive privilege over something that is an evidentiary hearing to determine whether there is an official act and therefore a presidential prerogative that would allow executive privilege. So this is the inquiry that would answer the question of whether there would be executive privilege over a certain set of acts or certain conversations or certain conduct uh, and certain decisions made. So I don't see how the executive privilege, roadblock can work in this particular case. The second one is the speech or debate clause when it comes to Donald Trump's communications with Vice President Pence and then his communications with other members of Congress. Mind you, when when Vice President Pence acts as the president of the Senate in the certification of the votes, that at that time Pence is working as an official of the legislative branch, and the speech or debate clause would preclude any sort of divulging of information, of conversation or interactions that Mike Pence had with other members of the legislative branch, not with the head of the executive branch. In fact, the whole purpose of the speech or debate clause is to shield and protect the legislature from an overreaching executive. Therefore, the speech or debate clause, if he were talking about Mike Pence was in his capacity as the president of the Senate, and when talking about these fake electors and pressuring Mike to, accept the fake electors, all of these steps that Donald Trump took were were as a candidate, as an office seeker, and as an executive, if he wants to say it, not as somebody in the legislative branch. Therefore, the speech or debate clause immunity for Mike Pence doesn't work. The speech or debate clause, similarly with other members of Congress, also don't work simply because speech or debate clause is meant to protect members of Congress itself, from an overreaching executive. Then there is the protection of the Fifth Amendment right against self incrimination. Of course, everybody who would find themselves to be self incriminated if they were to testify in the evidentiary hearing, they can come to an agreement with the DOJ of an immunity, or they can, and then they testify, or they can just plead the fifth and it goes on it goes on the record as they pled the fifth, and the DOJ would have to, think about how they would go about that particular witness. Uh, so all of these different mechanisms that Donald Trump wants to put forward, and in order to delay the evidentiary hearing, they're already setting it in motion, already setting in place. They said this would happen last month before Judge Chutkan even got the case back. And in the last few days that Judge Chutkan has the case back, Donald Trump has moved to dismiss the case on statutory grounds, and he has moved to dismiss the case on grounds of vindictive and selective prosecution. Both of those motions have been denied by Judge Chutkan, and Judge Chutkan wrote a 16-page order explaining why she denied the motion for vindictive and selective prosecution. In fact, essentially saying that Donald Trump did not meet the burden. The evidence is not there to prove that. So, with that said, we now wait for Judge Chutkan's hearing on August 16th. I suspect that we are going to see prompt decision by Judge Chutkan to set hearing dates and to determine who is going to be, if there are going to be witnesses, if there are going to be just legal discussions. That depends, and that depends on Judge Chutkan and Judge Chutkan's reading of the instructions that she has received. So with that said, thank you so much for being here, and please like, and I will come back to you as soon as there's news on this matter. Suffice it to say that Judge Chutkan is not holding back, and she's not waiting around. And Donald Trump is already trying to delay the proceeding of a SCOTUS-ordered evidentiary hearing. With that said, thank you so much. Take care.